and bound right in a crime with too many times. It's all the ounces of town, but a railroad tracks where the country moon shines.
I'm gonna ask you.
Yeah.
Do you think possession of stolen property is a misdemeanor or a felony?
I think it's felony. I don't know.
What do you think the fine should be? And or did you know what the fine is?
I don't know what the fine is, but I'm assuming that it fluctuates like what was stolen. I don't know. I mean, to steal a candy bar is probably not the same as like, steal something like, like something really expensive.
What do you think the jail time would be?
I don't know. I mean, probably not any longer than like a week or a month. I don't know.
For stealing?
Yeah, I don't know.
What, a candy bar?
I don't know. That's what I'm saying.
Do you think that if somebody purchased stolen property not knowing it was stolen, should have to return the property to the rightful owner?
Yeah. That always sucks when stuff you have gets stolen.
What about should they be convicted even if they didn't know it was stolen?
No, I don't think so.
What if the person was intoxicated and didn't know they stole property and realized it the next day and decided to return it back to the owner? Do you think they should be convicted of that crime?
Well, yeah, because they still stole it. I mean, returning it, I don't really know, but they still stole it, so, sucks to suck, I guess.
What about you? Do you think that possession of stolen property is a misdemeanor or a felony?
Felony.
What do you think that the jail time would be for that crime? And if there should be a fine?
I think there should be a fine and a little bit of jail time. Like
A month in jail. Do you think that if somebody purchased the stolen property not knowing it was stolen, do you think they should be convicted of that crime?
Yeah.
What about if the person was intoxicated? And they realized it was stolen the next day and tried to return it to the owner. Do you think they should?
If they try to return it, I think they should be let off.
What about you? Do you think possession of stolen property is a misdemeanor or a felony?
Yeah.
Both? Okay. Can I ask you a few questions?
Sure. What's up?
Do you think that possession of stolen property is a misdemeanor or a felony?
I believe it's a felony if the value of the property is high enough.
What do you think the fine for possession of stolen property is and the jail time for that crime?
What it currently is?
Yeah.
Or what I think it should be?
Yeah, both.
Currently, I believe the fine is contingent on how much is stolen and what the value of it is and the circumstances around it. But somewhere around $5,000 to $10,000. Jail time again varies on the seriousness of the crime. Anywhere from 6 months to 20 years in jail.
Do you think that if somebody purchased stolen property not knowing that it's stolen, do you think they should be convicted of a crime?
Absolutely not.
Should they be convicted even if, what about if they were drunk or intoxicated, didn't realize they did that, and then the next day try to return the stolen property?
Again, it's based on circumstances, but I don't think being intoxicated is an excuse for doing bad things. I think you need to learn from your mistakes. So I would say you should be prosecuted the same as anybody else stealing property, whether it's intoxicated or sober.
Now that we've gotten the opinions of some of our willing pedestrians off the streets, let's talk about possession of stolen property. We're going to go over the law that prohibits possession of stolen property, a good faith buyer of stolen property, and what a strict liability crime is. The first one is that we're going to talk about is a law that prohibits possession of stolen property, which is the California Penal Code 496. This would include person buys or receives stolen property constituting the theft or extortion. This would be conceals, sells, withholds, or aids in concealing, selling, be so stolen or obtained. This could include a misdemeanor or a felony and an imprisonment in jail. And a misdemeanor, the property cannot exceed $950 to consider it a misdemeanor, and it's up to 1 year in the county jail with a maximum fine of $1,000. To be considered a felony, it depends on the circumstances and the criminal history of the person with possession. 60 months or 2 or 3 years in the California State Prison with a maximum fine of $10,000. In principle and actual theft of property, the person cannot be convicted of both. They'll either be convicted of being the principal person that actually stole the property or in possession of the property. For a swap meet vendor, for an example, if the vendor buys or receives stolen property with a value of $950 or less, they actually have the legal right to inquire regarding the person that sells or delivers, if it was legal or not, if the property is theirs to sell. The vendor may be guilty of a misdemeanor if they do not inquire about the property. For the good faith buyer of the stolen property, we're going to go over the title of the property and their defense if they were caught with possession of property. The title of the property has no validity in the title of the property by a good faith buyer. They were not able to buy it to begin with because of it being of stolen property, so there is no valid title. They will never receive title for this property. And the actual owner may recover the property for these stolen items. Now, if a good faith buyer is caught with possession of stolen property, their defense could be the mistake of fact, a claim of right, and also innocent intent. And the mistake of fact, this would include if they did not know the property was stolen. They will not be convicted of the crime using the mistake of fact for defense. In a claim of right, this would be if the property was theirs to begin with. And somehow, for an example, if the property was stolen from them to begin with and resold, and they obtained the property, and at this time it was actually claimed as stolen, they do have the claim of right to that property. It was theirs to begin with. For innocent intent, this would include intended to return the stolen property to the rightful owner or police. So say like the buyer knew the property was stolen, but their intention was to return it to the rightful owner or the police. That would be their defense in possession. The last one would be the voluntary intoxication. This depends on the actual circumstances. They could use that as a defense, but that is rare in a voluntary intoxication. The last one we're going to talk about is strict liability crime. The regulatory offenses is the mens rea guilty mind, as it states, and also their intentions. It is considered a strict liability crime if they do have the guilty mind to steal the property or have in possession of the property, and that was their original intention. In the absolute liability of offenses, it's the knowledge of the offense, the knowledge that they knew that the property was stolen, but they still bought it anyhow. And the last one is the public welfare offense. This is called recklessness. If they are reckless in the crime and they knew of it being of stolen, it is considered a strict liability crime. And that's it for the possession of stolen property.